Hey, hi, my friends. Yeah, this is Joseph again. Um, yeah, it's another day. We got another new presentation, and so if you are very new to the to my channel, I kindly and humbly request you that you may subscribe, so that all the videos and the live stream I will be uploading, you won't miss them. Today is another interesting day. We're going to run about how to get legal status in the United States, in America. We got so many undocumented immigrants. So today we want to see how you can transform your status from illegal status to legal status in the United States. And please follow up to the whole video so that you don't miss any information about that. So we have 4 parts to legal status for undocumented immigrants in the United States. And I'll list them down for you. I'll explain every details of those the 4 ways you can get legal status in the United States. For undocumented immigrants in the United States, life can be very difficult. The stakes are very high. Getting caught means a likely removal, what we call deportation, from the United States. But it also may break apart a family, disrupt the family's finances, and result in stiffer immigration penalties. Currently, there is no extensive amnesty program like President Reagan introduced in 1986, but there are a variety of smaller programs that offer paths to legal status for certain undocumented immigrants. For undocumented immigrants, the clear goal is a path to a longer-term legal status. These paths to legal status lead to permanent residence, which we call green card or diversity visa program, and U.S. citizenship. So certain immigrants with no legal status may have some paths available. These articles, excuse me, this article covers those options and who could qualify for them. In this article, the term undocumented immigrant is used to describe an immigrant with any legal immigration status, without any legal immigration status. No status may be the result of entering the United States without inspection or entering via a legal non-immigrant visa, e.g., for example, tourist visa or student visa that has since expired. The term entered without inspection, or EWI for short, is used to specifically describe someone that has come across the border and never interacted with a U.S. border agent. Although there are approximately 650,000 childhood arrivals protected by the DACA program, which is a very popular program here for the children, this is not a lawful immigration status. It is a temporary solution and provides extremely limited opportunity for the beneficiaries. DACA recipients need paths to legal status like any other undocumented individual. Although not everyone will qualify for this path, they are worth learning about. The DACA, as the statement reads, is a very temporary solution for children who have been born in the United States by illegal immigrants. I think we'll discuss that later. So breaking down those 4 categories or 4 pathways of obtaining legal status, there are 4 of them. There is a green card through marriage to a U.S. citizen or through permanent resident. Then there is Dreamers, the one we just talked about, the DACA. Dreamers, green card through employment with Life Act protection. Then asylum status. Then we have the U visa for victims of crime. So one of the most common questions and most common paths to legal status is the treatment of an immigrant without legal status when he or she marries a U.S. citizen or lawful permanent resident. We're talking about the permanent residence or green card through marriage to a U.S. citizen or a permanent resident. So for the immediate relative relatives of our U.S. citizens, obtaining a green card may be a fairly straightforward process. In fact, a lawyer may not even be necessary. For all others, the process gets complicated, but it may be a viable path to legal status. So that's the only exemption where you don't need a lawyer. When you are getting married to a U.S. citizen, it's kind of automatic, unless you don't meet all the requirement, which is tabulated by the program. So we have immediate relatives of our U.S. citizens. It's important to understand that immediate relatives of a U.S. citizen include only the spouse, parent, or child at age 21. This provides the immediate relative, provided the immediate relative had a lawful entry to the U.S., he or she may adjust status to permanent resident, or the green card status, or the permanent residence. In other words, the undocumented immediate relative may apply for a green card from inside the United States. The lawful entry is essential. The undocumented individual must have entered the United States with valid documentation and made face-to-face contact with a U.S. immigration officer, and that officer acknowledged the person entry to the U.S. Therefore, an individual who overstays a visa and then marries a U.S. citizen may generally obtain a green card through adjustment of status. So it doesn't matter if the visa overstay was only 6 months or 6 years, the undocumented immediate relative has the ability to apply for a green card. So it don't matter whether you have overstayed, but once you get married to a U.S. citizen, it's automatically, it overrides everything. So I think that's the safest way of getting, acquiring or obtaining U.S. citizenship. Then there is I-601A provisional waiver. There is a waiver which traditionally has always been possible for the undocumented spouse and her own dependent children to gain permanent residence status through the marriage to the U.S. citizens or permanent resident. The reality is, however, that the immigration process is not always that easy. So is a warning here. There are many issues that become pitfalls to spouses or stepchildren of U.S. citizens and permanent residents as they contemplate filing for legal residence status. By law, if the foreign spouse and children or stepchildren enter the U.S. without inspection and remain in the U.S., they must leave the country and conclude the immigration process through U.S. consulates abroad to obtain the immigrant visa or green card. More importantly, if the immigration spouse or children over 18 years of age resided in the U.S. unlawful for at least 180 days or 6 months, they could then be automatically barred from re-entry to the U.S. for 3 to 10 years once they leave the U.S. So you have to be very careful. So I think you have to abide with all these regulations, and you have to qualify. You have to meet all these requirements. Otherwise, the process won't go through. In many cases, these processes can qualify and apply for a waiver of 3 and 10 years bar if they can demonstrate that the absence from the U.S. would cause an extreme and unusual hardship to the U.S. citizen or lawful permanent resident, spouse, or parent. In the recent past, the waiver process required that the individual first travel out of the U.S. and apply from his or her own country of origin. This was a costly and very uncertain process that still risks keeping families apart, for a very lengthy period of waiver approvals, or even worse, waiver denials and full exposure to the 3 to 10 years bar. That might be a long process. Fortunately, that process is a thing of the past. So now things are easier. So the government have tried to ease the process. So a provisional waiver is now available that can be applied for and obtained while the applicant is still in the United States. The provisional waivers offers individuals some level of certainty that once approved, they will be able to return to the United States after a successful consular interview. The provisional waiver program covers the undocumented spouse and children of U.S. citizens. So the goal of the provisional waiver program is to maintain family unity. Extreme and unusual hardship can generally include family ties to the United States and the country of removal, conditions in the country of removal, the age of the U.S. citizen or permanent resident spouse or parent, the length of residence in the United States, relevant medical and mental health conditions, financial hardship and education hardship. Those are just but a few of them. Applicants should remember that it must be a bona fide, or it have to be a legal marriage to the U.S. citizen, that all previous marriages must have been lawfully terminated. Marriage fraud, or like a fake marriage to get a green card, carries harsh penalties that could even result in a federal conviction for the U.S. citizen. So you have to be very careful when you are processing these things. You can't fake anything. You have to be honest and very upfront and very genuine with whatever you are doing during this process of application. So prospective applicants should always speak to experienced immigration attorney before applying for a provisional waiver, which is they use the form I-601A, application for provisional and lawful presence waiver. Although it may seem like a fairly straightforward process, these waivers are highly technical and require careful and thorough legal analysis. Your answers on the application could have long-term implications to your immigration case. So that's through. I have just explained about how to get legal status through U.S. citizen marriage, through their marriage to a U.S. citizen. Then we have Dreamers Green Card or permanent residence through employment with Life Act protection. There are certain situations where dreamers who have had the opportunities to receive higher education become candidates for higher skilled jobs. In such a scenario, U.S. employer may be interested in sponsoring the green card for a high-skilled prospective employee. Yet even if a dreamer is protected under DACA, he or she may still need the benefits of 245 protection through the legal immigration family equity. There are many cases where undocumented immigrants, particularly well-educated dreamers, may have an employer who is willing to sponsor him or her for a green card. In some instances, the employer will need to go through a process known as labor certification or PERM prior filing for the prospective dreamer's employment visa petition. However, even after such a process is successfully completed, the process still requires the immigrant to return to his or her own country because of his or her regional unlawful entry or out of status condition. Yet, if the individual has 245 protection, he or she can complete the process in the United States and obtain a green card without leaving. You don't have to leave the United States when you are doing this. The Life Act is a law that allows undocumented immigrants to finish their green card process in the United States if an immigration petition was filed on their behalf or on their parents' behalf on or before April 30, 2001. For example, if the dreamer's U.S. citizen paternal uncle filed an immigration petition or Form I-130 petition on behalf of the dreamer's father by April 30th, 2001, then not only the father but the son or daughter may be covered by the Life Act's 245I provision. So that's the program explained. This is a simplified presentation of the law and many additional requirements must be met. So every program of these processes, all the requirements have to be met. Otherwise, you can process without the requirement met. If these scenarios sound like it may apply to your situation, you need to speak with a very experienced immigration attorney that can explain the details. If you don't understand these details or this information, you have to consult somebody who got all the information before you start the application process. Then we have asylum status, very common. Asylum status is available to anyone in the United States who has suffered persecution in his or her home country or who has a well-founded fear of prosecution that have happened to most native of Somalia, Sudan, for example, or Rwanda, Burundi, Haiti. Those are some of the examples of asylum seekers. So if any of those were to return to that country, it is important to understand that the persecution must be done by the government or by a group that the government is unwilling or unable to control. So that has to be a national level thing. It can be like you are fighting with your family or there is family conflict that cannot meet that requirement. It has to be a government or a big institution or national institution, like Boko Haram in Nigeria. That's very also a very legal way that you can file or you can seek for asylum in the U.S. In U.S., immigration or persecution is very well defined. Most importantly, the persecution must be on account of one of the following 5 groups: race, religion, nationality, membership in a particular social group, or political opinion. In general, eligibility for asylum requires that you are present in the United States by legal or illegal entry. You are unable or unwilling to return to your home country due to past persecution or have a well-founded fear of future persecution if you return. The reason for persecution is related to one of the 5 things: race, religion, nationality, membership in a particular social group, or political opinion, and you are not involved with an activity that would bar you from asylum. So to begin an asylum case, your lawyer must file Form I-589, application for asylum and for withholding of removal, along with the evidence supporting your claim. There is typically a screening interview to make sure an applicant's case is warranted. This is why it is very important to work with a reputable organization or a non-profit or legal firm that is experienced with asylum cases. Asylees, those are the people who are seeking their asylum, are eligible to apply for a permanent resident status or green card 1 year after receiving the asylum grant. The asylee's spouse and children are also eligible to apply for a green card if they are admitted to the United States as asylee. So the last group or category for being legal in the United States for seeking legal status is U visa for victims of crime. In 2000, the Victims of Trafficking and Violence Prevention Act created the U visa to protect non-citizens who have been victims of certain crimes and who had aided law enforcement. The law was created to encourage victims to cooperate with police and prosecutors without the fear of deportation. A U visa provides legal status, employment authorization, and can also provide a path to permanent resident status, green card in some circumstances. Therefore, eligibility requirement for U visa. Number 1, the individual must have suffered substantial physical or mental abuse as a result of having been a victim of a qualifying criminal activity. Number 2, the individual must have information concerning that criminal activity. You can explain the criminal activity violated U.S. laws, and the individual must have been helpful, is being helpful, or is likely to be helpful in the investigation or prosecution of the crime. So the qualifying criminal activity for a U visa include but are not limited. This is what you should report to qualify: abduction, abusive sexual contact, blackmail, domestic violence, extortion, forced imprisonment, female genital mutilation, female genital mutilation, felonious assault, hostage, incest, involuntary servitude, kidnapping, manslaughter, murder, obstructions of justice, peonage, perjury, prostitution, rape, sexual assault, sexual exploitation, slave trade, torture, trafficking, witness tampering, unlawful criminal restraint, other related crimes. Additional details about qualifying crimes can be found on the USCIS U visa page. The victim must have useful information related to the crime and be willing to cooperate with police. And